If this was useful, there's a lot more where it came from. Other specific situations, other specific rights, all covered with the same care we're putting into today's topic. Subscribing is the easiest way to make sure you don't miss the next one, especially since a lot of these topics tend to become relevant exactly when you least expect it, which is exactly why it's worth having them ready in advance rather than scrambling to look them up in the moment. All right, let's keep going with today's topic.
Your phone is in your pocket right now, or maybe it's sitting on the table next to you, or charging on the nightstand, or face down on your desk. And on it right now is probably more information about your life than exists anywhere else in the world. Your texts, your emails, your photos, your location history, your search history, your banking apps, your medical apps, your notes to yourself at 2 in the morning, the conversations you've had with your attorney, your doctor, your partner, your kids. All of it, compressed into a device that fits in one hand, and all of it potentially accessible to law enforcement the moment that device leaves your possession, unless you understand exactly what the law says about when and how that access is actually allowed. Here's what I want you to walk away from this video knowing so completely, so automatically, that it's available to you without any hesitation in the moment it matters most. Being arrested does not give police the automatic right to search through your phone. It does not. The fact that you are in handcuffs, the fact that your phone has been physically taken from you, the fact that an officer is standing there holding it and looking at it, and maybe even asking you to unlock it right now, none of that, standing alone, gives them legal authority to go through what's inside. That moment, that specific, high-pressure, disorienting moment, is one of the most important moments in your entire interaction with law enforcement, and almost nobody handles it correctly. Not because they're careless, but because nobody ever sat them down and walked them through what that rectangle in their pocket is actually protected by. Before we get into exactly how this works and exactly what to say when it's happening to you, hit subscribe right now if you actually want to know your rights before you need them, rather than learning them afterward. That's the entire point of everything on this channel. Quick note before we go deep. This is legal education and commentary, not specific legal advice, and some of the finer details here can shift from state to state. But the foundational principles we're going to walk through today come directly from a Supreme Court decision that applies everywhere in this country, and you absolutely need to understand it. Let's get into it. Let's start at the foundation, because everything in this video is built on a single case, and understanding that case changes how you see every piece of what comes after. In 2014, the United States Supreme Court decided Riley v. California, and it was not a close call. It was unanimous. 9 justices, who agree on almost nothing, agreed completely and without reservation on this. Police generally cannot search the contents of your cell phone incident to arrest without first obtaining a warrant. Before Riley, the rule in most courts was that when police lawfully arrested someone, they could search pretty much anything found on that person at the time of the arrest. Right there, right then, no warrant needed, as what courts called a search incident to lawful arrest. The idea was officer safety and preventing evidence from being destroyed. If you had a knife in your pocket, they could search your jacket. If you had a paper note in your wallet, they could read it. The theory was that items on your person at the time of arrest were fair game. And then Riley asked the obvious question that the entire legal system had somehow been avoiding.
I want to be upfront about something, because I think it's important to say directly, rather than bury in a quick disclaimer. General legal education, including everything we do here, has real limits, and it's worth understanding exactly where those limits are. What we can do here is give you a strong, accurate, genuinely useful foundation, the kind of understanding that changes how you experience a real situation when it happens. What we can't do here is account for every specific variation, every local nuance, every unique detail of your particular circumstances, because that's simply not something general content is built to do, no matter how thorough it tries to be. That's exactly why the foundation matters so much, though. A strong general understanding is what tells you when a situation is straightforward enough to handle with what you already know, and when it's specific and serious enough that it's worth bringing in someone who can look at your exact circumstances directly. All right, keeping that framing in mind, let's get into it.
Is a smartphone just a more sophisticated version of a paper note in a jacket pocket, or is it something categorically different? The Supreme Court looked at what smartphones actually are. They looked at what they actually contain. Chief Justice John Roberts, writing for a unanimous court, compared it to this. A pre-digital camera could hold a few dozen photographs. A smartphone can hold millions. A person might carry a couple of letters in their pocket. A smartphone contains every communication they've sent or received in years. It has their location history, it has their medical information, it has their financial records, it has their most private thoughts. The court said, in language that's worth actually hearing, that modern cell phones are not just technological conveniences. They are such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. And because of everything they contain, they are categorically different from the physical items that the old search incident to arrest rule was designed to cover. The court held that the rationale behind that old rule, officer safety, preventing evidence destruction, doesn't apply the same way to the digital contents of a phone. An officer's safety isn't threatened by whatever is sitting in your photo library. Data isn't going to jump out of the phone and physically harm anyone. And as for evidence destruction, the court pointed out that there are actually specific technical tools available to preserve digital evidence without reading it. The conclusion was firm and clear: get a warrant. Before you search through the contents of someone's phone, go get a warrant. That single sentence, from a unanimous Supreme Court, is the foundation of everything that follows in this video. And yet, understanding that the rule exists is only the beginning, because the rule doesn't enforce itself, and the gap between what the law says and what actually happens in a real arrest is enormous, and that gap exists precisely because most people don't know Riley exists at all. Let's talk about what actually happens in that moment, because knowing the abstract legal rule matters far less than knowing what to do when you're standing in a parking lot in handcuffs and an officer is holding your phone and asking you to unlock it. Or when you've been brought to a station and an officer is sitting across from you saying something like, "Just unlock the phone and we can clear this whole thing up." Or when they're telling you it will go a lot easier for you if you cooperate, that they just want to check one thing, that it'll take 2 seconds, that refusing is only going to make this harder. These are real things that happen in real encounters, and the pressure they create is real, and it's designed to feel like your only option is to comply. It isn't. Let's walk through the scenario in a specific, granular way, so you have a clear picture of what's happening and what your actual options are at each point. You've been arrested. The circumstances almost don't matter for this specific question. Maybe it's a DUI, maybe it's a misdemeanor, maybe it's something you're completely sure is a misunderstanding that will get sorted out. The officer has your phone. This is where a lot of people make the first mistake without realizing it's a mistake. They hand over the phone voluntarily, or they unlock it voluntarily, because they're thinking about the arrest itself and not thinking about the phone as a separate thing, with its own set of rights surrounding it. The phone has been seized at this point, meaning it's physically in police possession, and that part is generally fine and legal incident to a lawful arrest. They can take it, hold it, secure it. Taking physical possession of the phone is different from reading its contents. What they cannot generally do without a warrant is go through what's on it. So, the first thing to understand is that when an officer takes your phone, that does not mean they have any right to look at what's inside it. Those are two completely separate things. Taking the device and accessing the device's contents are two separate acts governed by two separate legal standards. The taking is allowed, the reading is not, without a warrant or an exception. Now the officer asks you to unlock it, or maybe they just ask for your passcode directly. Or they tell you to use your fingerprint or your face. Here's the move, and it's a simple one delivered calmly. I don't consent to a search of my phone. That's the sentence. 5 words plus the setup. You're not going to unlock it without a warrant. You're not trying to hide anything. That framing is irrelevant. You have a constitutional right, backed up by a unanimous Supreme Court decision that says this requires a warrant, and you're going to exercise that right. Say it simply, without escalation, without attitude, without trying to have a legal debate on the side of the road. I don't consent to a search of my phone. Now let's talk about what happens in response to that, because there are several different directions this can go, and each one deserves a clear walkthrough. The first direction is the most straightforward. The officer accepts it, maybe not enthusiastically, maybe with visible frustration, but they don't pursue it further at that moment. This is actually what should happen under the law, and when it does, it means that if they want to go through your phone, they now need to go get a warrant, which means they need to go to a judge and show the judge that they have probable cause to believe the phone contains evidence of a specific crime. That's not nothing. That process exists specifically as a check on exactly this kind of intrusion, and it's doing its job. The second direction is that the officer tells you that you have to unlock it. that you don't have a choice, that refusing is obstruction or some other offense. This is where you need to stay calm and stay steady, because that claim is generally not accurate, and backing down from a correct legal position because of confident, incorrect pressure is how these encounters go wrong. You can respond to this without arguing about the law. I understand, but I don't consent to a search of my phone, and I'd like to speak with an attorney. That's it. You're not debating Fourth Amendment doctrine with an officer on the street. You're stating clearly that you don't consent, and you're invoking your right to counsel. Both of those things matter, and both of those things need to be said out loud and on the record. The third direction is that the officer says they're going to search it anyway, and just does it. If this happens, you do not physically resist. You do not grab for the phone. You do not yell or escalate. What you do is continue to repeat clearly, "For the record, I don't consent to this search." You say it as many times as necessary, calmly, consistently. You're creating a record. If that officer searches your phone without a warrant and without a valid exception, that search may be suppressible later, meaning anything found might be thrown out of court entirely, but only if your non-consent is clearly established. Your verbal non-consent, stated clearly and repeatedly, becomes a critical piece of that later argument. The fight about whether what they found is admissible happens in a courtroom with an attorney, not in a parking lot. What happens in the parking lot is you create the clearest possible record of not having consented. Let's talk about the exceptions to Riley, because Riley is not an absolute rule with zero exceptions. And understanding when exceptions might apply is just as important as understanding the rule itself. The first major exception is consent. We already covered this, but it deserves repeating explicitly in the context of phone searches because it's the exception that eliminates the rule most often in practice. If you unlock the phone yourself, if you hand it over unlocked, if you tell them the passcode, if you confirm a fingerprint or a face scan, you have consented to the search. The warrant requirement exists to protect you from government intrusion you didn't agree to. Once you agree to it, that protection is gone. This is why the number one most important thing you can do in this specific scenario is know, in advance, before this ever happens, that you are never required to consent, and make the decision, consciously, right now, that if this ever happens to you, you will not. Not because you have anything to hide, because it's your right, and because waiving it under pressure in a high-stress moment is exactly the kind of decision you'll wish you'd made differently later. The second exception is exigent circumstances, which we covered in the context of entering your home in other work on this channel, and it applies here too, though courts have generally been skeptical of applying it broadly to phone contents given how specifically Riley addressed the evidence destruction concern. In theory, if there were a genuine, documented, specific emergency where waiting to get a warrant would result in serious harm or irretrievable destruction of evidence, a warrantless search might survive legal challenge. In practice, this exception is narrow, and officers claiming exigent circumstances to justify a warrantless phone search have to actually be able to demonstrate that the circumstances genuinely existed. It's not a magic word that eliminates the warrant requirement whenever it's invoked. The third exception is that sometimes officers simply act without authority and search the phone anyway, and the question becomes not whether the search was lawful in the moment, but whether the evidence they found can be used against you. This brings us to something called the exclusionary rule, which is the legal mechanism that actually gives the Fourth Amendment its teeth in criminal proceedings, and it's worth understanding clearly. Let's talk about the exclusionary rule, because this is the part of Fourth Amendment protection that makes the whole thing real rather than theoretical. The exclusionary rule says that evidence obtained through an unconstitutional search or seizure generally cannot be used against you in a criminal trial. The idea behind it is straightforward. If illegally obtained evidence could be freely used in court, the constitutional prohibition on illegal searches would have no real enforcement mechanism. If police could search your phone without a warrant, find evidence, use it against you, and face no consequence for having done so, the rule against warrantless searches would be essentially meaningless. The exclusionary rule creates the consequence. The unconstitutionally obtained evidence gets excluded, suppressed, thrown out. What was found becomes legally invisible in your case. Now, this doesn't mean every unconstitutional search automatically results in a dismissal of charges. Sometimes there's other evidence. Sometimes the suppression only affects part of the case. Sometimes there are sub-exceptions to the exclusionary rule itself. But understanding that an unconstitutional search of your phone can potentially result in the evidence being thrown out entirely is understanding why it matters so much that you don't consent to the search in the first place, and that you clearly state your non-consent if they proceed anyway. You are building the argument for suppression. You are laying the foundation, right there in the moment of the arrest, for a motion that might change the entire outcome of your case. Let's talk about what a warrant for your phone actually involves, because this is something a lot of people have a vague sense of, but don't really understand in detail, and the details matter. When police want to search your phone with a warrant, they have to go to a judge and present what's called an affidavit, essentially a sworn document explaining what they know, why they believe the phone contains evidence of a specific crime, and what specifically they're looking for. The judge reviews that affidavit and decides whether there's probable cause to justify the search. Probable cause means something specific legally. It means a reasonable person, looking at the available facts and circumstances, would conclude there's a fair probability that the phone contains evidence of the crime described. It's not certainty, it's not proof beyond reasonable doubt, but it's something concrete, specific, and reviewable by a neutral judge, which is an enormous improvement over no oversight at all. If the judge issues the warrant, it typically specifies what they're authorized to search for on the phone. It might authorize them to search for specific categories of messages, or photos from a specific date range, or records related to a specific transaction. In theory, and increasingly in practice as courts grapple with this, the warrant should be particularized, meaning it should specify what they're actually looking for, rather than authorizing a general rummaging through everything on the device. In practice, the scope of phone search warrants is still an evolving area of law, with courts still working through exactly how much limitation is required, but the warrant requirement itself is clear and firm. Here's something worth understanding about how this actually plays out once a warrant is obtained. The search often doesn't happen right there on the side of the road. Officers may seize the phone at the time of arrest, place it in a Faraday bag or some other protective container to prevent remote wiping, get the warrant afterward, and then use forensic tools in a controlled environment to extract and examine the phone's contents. This can take days, sometimes longer. The phone you lost in an arrest might be sitting in a lab being forensically examined a week later, after a warrant was obtained post-arrest. The seizure and the search can be separated in time by a significant gap, and that's actually consistent with Riley, which is specifically about the search of the contents, not the physical seizure of the device. Let's talk about biometrics versus passcodes, because this distinction matters more than most people realize, and it's something you genuinely want to understand before you're in a position where it's relevant. There's a legal difference, still being developed across different courts, but increasingly significant, between compelling you to provide a passcode and compelling you to provide a fingerprint or face scan to unlock your phone. The reasoning comes from Fifth Amendment territory. The Fifth Amendment protects you against being compelled to be a witness against yourself, which courts have interpreted to cover the contents of your mind, meaning a passcode, a combination, a password, something you know, may be protected against compelled disclosure in a way that your biometric data, something you are, like your fingerprint or your face, may not be. The argument is that compelling you to say your password is compelling you to produce testimonial evidence from your own mind, whereas pressing your finger to a screen is more like compelling a physical act, similar to a blood draw or a DNA swab, which courts have generally treated differently from compelled speech. This area of law is genuinely unsettled and varies significantly by jurisdiction, and different courts have reached different conclusions. But as a practical matter, it means this. If you're concerned about police being able to access your phone, a strong alphanumeric passcode may provide more protection than biometric unlocking alone, both because of this developing legal distinction and because under stress you might accidentally provide a fingerprint or face scan without fully realizing what you're doing, in a way that's harder to do accidentally with a memorized code. This is practical, forward-looking preparation, not paranoia, and it's worth thinking about now rather than afterward. Let's talk about cloud data specifically, because this is an aspect of phone privacy that surprises people, and it's genuinely important to understand. When police obtain a warrant to search your phone, that warrant typically applies to the physical device. But an enormous amount of data that lives on your phone is actually stored in the cloud, on Apple's servers, on Google's servers, in various third-party services that sync with apps on your phone. Accessing that data often requires a separate legal process, either a separate warrant directed at the service provider or a court order under the Stored Communications Act, or some other legal mechanism depending on the type of data and where it's stored. The fact that a photo or a message is accessible through an app on your phone does not automatically mean that police can reach the servers it's stored on using only the warrant that applies to your device. The cloud provider may receive a separate legal demand, and they may or may not have their own notification obligations to you, depending on the type of demand and the circumstances. This is a nuanced area of law, but the important practical point is this. The boundaries of a phone search warrant are not automatically unlimited just because the phone is a window to an enormous amount of additional data. The warrant has boundaries, and the digital infrastructure you rely on may have its own legal protections worth understanding. Let's talk about what to do with your phone before an arrest is ever something you're thinking about, because preparation here is genuinely valuable and the steps are simple. Use a strong passcode, not a 4-digit PIN if you can help it. A longer alphanumeric passcode is significantly harder to brute force with forensic tools. Consider whether biometric unlocking adds convenience you want more than protection you might need. Think about what your phone automatically syncs and where. Think about whether there are conversations, documents, or data on your phone that would matter to you in the context of any kind of legal trouble, and think about what protections you've put around them. None of this requires being paranoid or having anything to hide. It requires recognizing that your phone contains more intimate details of your life than any object that has ever existed before, and treating it accordingly. Let's talk about the request to just check one thing, because this is one of the more common pressure situations you might encounter in this context, and it deserves its own careful walkthrough. Sometimes the ask is framed not as, "we want to search your phone," but as something much smaller and more specific. Can you just show me the last text you sent? Can you just open your photos from last Tuesday? Can you just let me see who you called at 8 o'clock? These framings are designed to feel like small, reasonable, specific requests rather than the full phone search that they actually enable the moment you unlock the device and hand it over. Because here's the practical reality. Once the phone is unlocked and in an officer's hands, the scope of what they actually look at is not always limited to the one thing they asked about, and your consent to show them one text doesn't come with a guaranteed legal stop sign that prevents them from seeing everything else that's on the screen while they're holding it. Consent to show them something specific can create ambiguity about how far the consent extended, and that ambiguity doesn't tend to resolve in your favor. The cleaner, more protective move is the consistent one: "I don't consent to a search of my phone." Not, "I don't consent to you reading the whole thing, but you can see this one thing." Just the single clear refusal, consistent and complete. Let's talk about what happens if police get a warrant and you still don't want to unlock the phone. This is a different situation from refusing without a warrant, and it's worth understanding the difference clearly. If a valid search warrant has been issued by a judge and it covers the contents of your phone, you are in a different position than you are when they're simply asking without one. That warrant represents a judicial finding that probable cause exists, and it authorizes the search. You can still state clearly that you don't consent to the search, because that statement costs nothing and preserves the record in case the warrant is later challenged. But the calculus about cooperation has shifted. If the warrant compels you to provide your passcode specifically, that legal question, whether you can be compelled to hand over the contents of your mind in this way, is one that your attorney needs to be involved in evaluating in your specific jurisdiction. Because, as we talked about earlier, this area of law is genuinely not uniform across the country, and the right answer depends on where you are and what the specific circumstances are. This is precisely why getting an attorney involved as early as possible in any arrest that involves your phone is so important, not just in general but specifically for this question. Let's talk about the attorney piece of this more directly, because it's been mentioned a few times already and it deserves its own clear statement. The moment you've been arrested, you have the right to an attorney. Not after processing, not when it's convenient, not after answering a few preliminary questions first. You have the right to an attorney, and you have the right to remain silent until you have one. These two rights work together in the context of a phone search specifically, because your attorney needs to know, as early as possible, that police have your phone, whether you consented to unlock it, whether they've made any attempt to search it, and whether any warrant has been sought or obtained. This is time-sensitive information that your attorney can potentially act on if they know about it early enough. The moment you're allowed to make a phone call, the moment you have any access to counsel, communicating the specific fact that police have your phone and what has been said about it is as important as communicating anything else about your arrest. Your attorney can file motions. Your attorney can challenge a warrant's validity. Your attorney can challenge whether the scope of the search stayed within what the warrant authorized. Your attorney can argue for suppression of whatever was found if the search was unlawful. None of that can happen effectively if your attorney doesn't know the phone is an issue, and it can't happen at all if you consented to the search before you ever spoke to anyone. Let's talk about something that comes up less often but is worth understanding. Specifically, what if police don't search your phone at the time of arrest, but ask to search it later? Maybe during booking, maybe at the station, maybe days later. The Riley rule doesn't have a time limit built into it that says you had to refuse at the scene for the refusal to matter later. Each request for access is a separate request. If you're asked to provide your passcode or unlock your phone during booking, during processing, during any subsequent interaction, the same framework applies. I don't consent to a search of my phone. I'd like to speak with my attorney. That request, stated clearly, at any point in the process, triggers the obligation for police to stop asking and to seek a warrant if they want to proceed. The door is not more open because you're now inside a station, rather than standing on a road. Let's talk about something a lot of people wonder about but rarely ask directly. Does it matter what kind of phone it is? What operating system it runs? What apps are on it? Legally, no. Riley applies to cell phones generally, and courts have consistently extended its logic to smartphones of every kind. The specific technical details of the device don't change the constitutional protection. What does matter, practically, is the encryption situation. Modern smartphones, by default, encrypt their contents in a way that makes forensic examination without the passcode extremely difficult. This is actually the reason the passcode question has become so significant. Without the passcode, many modern devices are genuinely very hard to access, even with sophisticated forensic tools. The encryption that your phone manufacturer has built into your device works alongside the constitutional protection Riley provides. The constitutional protection says they need a warrant. The encryption says that even with a warrant, they may need your cooperation or a technical workaround to execute it. Both layers exist, and both layers matter. Let's talk about what gets missed in the standard version of this conversation, the thing most people don't think about until they're in the middle of it. It's not just the contents of your phone that matter here, it's what accessing your phone might reveal about other people. Your messages are not just your messages, they're your conversations with other people. Your photos include other people. Your contacts represent other people's information. Your location history might place other people at certain locations at certain times. The private nature of what's on your phone is not just about protecting yourself. It's about the private information of everyone you've communicated with, everyone you've photographed, everyone whose number you have. When you think about whether to consent to a phone search, you're not just making a decision about your own information. You're making a decision about theirs. Let's talk about the common argument police sometimes make and that well-meaning people sometimes repeat without realizing what it actually implies. If you have nothing to hide, you have nothing to worry about. This argument is worth addressing directly, not because it's made in bad faith, but because it fundamentally misunderstands what privacy rights are for. The right against unreasonable searches doesn't exist only to protect people who have done something wrong. It exists to protect everyone, because the alternative, a world where authorities can search any person's most private information at any time without judicial oversight, is a world that most people, across the political spectrum, would recognize as deeply dangerous to freedom. The warrant requirement, and the specific application of it to phones in Riley, is not a mechanism for hiding wrongdoing. It's a mechanism for ensuring that access to the most private aspects of a person's life requires oversight by a neutral judge who can assess whether that intrusion is actually justified. The protection belongs to everyone equally, not just to people who have something specific to conceal. Asserting it is not evidence of guilt. It is, quite literally, the exercise of a right that a unanimous Supreme Court said you have. Let's talk about what the officer's demeanor in this moment is going to feel like, because this is the practical human side of something that's easy to discuss abstractly, but much harder to navigate emotionally in real time. Officers asking for access to your phone during or after an arrest are not always going to ask calmly. Sometimes they're going to be direct and professional about it. Sometimes there's going to be obvious irritation. Sometimes there's going to be pressure that doesn't feel explicitly threatening, but feels unmistakably like there is a right answer being suggested to you. Sometimes the framing is going to be strategic. We're just going to get a warrant anyway, so you might as well unlock it now. Or, this is your chance to show us there's nothing here. Or, Not cooperating only makes you look worse. These framings are worth recognizing for what they are, which is an attempt to get voluntary consent by making refusal feel pointless, suspicious, or disadvantageous. None of them change the underlying reality. We'll just get a warrant anyway, might be true, or it might not be. Getting a warrant takes effort, requires probable cause, requires judicial approval, and might not be granted. If they could easily get a warrant, they would just go do it, rather than spending time asking you. This is your chance to show us there's nothing here. Sounds cooperative, but actually showing them what's on your phone could reveal things completely unrelated to whatever they're investigating that might create entirely separate problems. And not cooperating makes you look worse is a social pressure argument, not a legal one. The law does not allow a jury to be told that you refuse to consent to a search of your phone. Refusing to consent is legally protected conduct, and it cannot be used against you as evidence of guilt in court. Knowing this, calmly, is enormously useful when you're standing in a parking lot and someone is making the refusing to cooperate argument sound very compelling. Let's talk about the specific scenario where you've been arrested and your phone is being held and you haven't been asked to unlock it yet. This is a moment a lot of people skip over, but it matters. If police physically have your phone and haven't yet attempted to search it, you do not need to wait for them to ask in order to state your position clearly. You can proactively say, to any officer present, I want to note that I do not consent to any search of my phone. Getting that statement into the record early, before any attempt is made, is useful, not because it changes what you'll say if they ask, but because it removes any possible ambiguity about your position and makes it harder for anyone to later claim that you consented in some implicit way. Be the one who establishes the record, rather than waiting for the question and responding to the pressure of the moment. Let's talk about a specific wrinkle that comes up in the real world, more than you'd expect. What if your phone is password protected, but it's already unlocked at the time of your arrest? Maybe you were actively using it. Maybe it unlocked automatically in your pocket. Maybe the screen is still on with an app open. Does the fact that the screen is on and readable change the legal analysis? This question has been litigated, and the general answer from most courts is that the phone being unlocked at the time of seizure does not give police general permission to search through its entire contents. Riley was specifically clear that the rationale behind search incident to arrest doesn't justify the digital search, and that rationale doesn't magically appear just because the screen happens to be on. What an officer observes in plain view on an open screen at the moment of arrest might be a different question, just as something in plain view in your car has different analysis than something in your locked glove compartment. But that's a specific, narrow situation, and it doesn't open the door to a general search of the entire phone. The screen was on when I arrested them is not a substitute for a warrant, and you can still clearly state your non-consent to any broader examination, regardless of what state the screen was in at the moment of seizure. Let's talk about what to do afterward, because this video has spent a lot of time on what to do in the moment, and the aftermath matters just as much, maybe more, for your actual legal situation. If your phone was taken during an arrest, your first conversation with your attorney needs to include everything you know about that phone. How was it taken? What was said? Were you asked to unlock it? Did you unlock it? Did you consent to anything explicitly or implicitly? Did you observe any officer looking at the screen? Was anything said about a warrant being sought? All of this is information your attorney needs to assess whether a motion to suppress is worth filing, whether there's a Fourth Amendment issue that could affect the admissibility of anything found, and whether the way the phone was handled at the time of arrest or afterward violated your rights in ways that matter for your case. Your memory of these details, like your memory of any encounter with police, is most accurate immediately afterward, and it should be recorded, written down, voice memoed, communicated to counsel, as soon as you possibly can. Let's also talk about something worth thinking about in the longer term. The fact that Riley was a unanimous Supreme Court decision doesn't mean the issue is fully resolved for all time and in all its dimensions. Courts are continuing to work through exactly what a phone warrant needs to specify, exactly how broad a phone search can be, exactly what exceptions apply to the warrant requirement in the digital context, and exactly how Fourth Amendment protections apply to all the data that touches your phone but lives elsewhere, in the cloud, on servers, in data brokers' databases. This is an area of law that is actively evolving, and the direction it's evolving in, broadly, is toward treating digital privacy with the same seriousness that Riley applied to the device itself. Understanding where the law is and where it's going is the kind of preparation that keeps you ahead of the moment rather than behind it. Let's talk about something that feels emotionally different from the straight legal analysis, but is genuinely important to sit with for a moment. The experience of being arrested, even for something minor, even for something that turns out to be a complete misunderstanding, is one of the most disorienting and stressful experiences a person can have. Your heart is pounding, time feels strange, the world has suddenly become very small, and very loud, and very close. This is precisely the condition in which it is hardest to think clearly, and precisely the condition in which you are most likely to hand over something you would never hand over if you were calm, seated, thinking clearly, and fully aware of your rights. Every single person who has ever unlocked their phone in that moment, and then wished they hadn't, did it in exactly those conditions. The goal of everything in this video is to get you to a place where you've made the decision about your phone before that moment ever arrives, so that in the moment, you're not deciding anything at all. You're executing a plan you made when you were calm and clear and fully informed. Let's talk about how to actually practice this, because saying it intellectually is different from having it in your body as something you'd actually do. The sentence is, "I don't consent to a search of my phone." Say it out loud right now. Actually say it. Not just read it. Say it like you're saying it to a real person. "I don't consent to a search of my phone." Now say the follow-up. "I'd like to speak with an attorney." Put them together. "I don't consent to a search of my phone, and I'd like to speak with an attorney." Now say them the way you'd say them under stress. Not loudly, not aggressively, just clearly, steadily, the way you'd say something you were completely certain about to someone who is pushing back on it. "I don't consent to a search of my phone. I'd like to speak with an attorney." These two sentences, said calmly and repeated as many times as necessary, are the entirety of your active role in this specific part of a police encounter. Everything else, every motion, every legal argument, every challenge to the warrant, every suppression hearing, that's your attorney's job. Your job in this moment is just those two sentences. Let's talk about something connected to all of this that deserves its own moment. What about your phone being searched during a stop that doesn't involve an arrest? What if you've been pulled over and an officer asks to look at your phone or asks you to show them something on it? Riley specifically addressed the search incident to arrest context, but the principles under the Fourth Amendment apply much more broadly than just arrests. A request to search your phone during a traffic stop where you're not being arrested is still a request for consent to search, and all of the same consent principles apply. You are not required to show an officer your phone during a traffic stop. You are not required to unlock it. You can say, calmly and simply, "I don't consent to a search of my phone," in exactly the same way, and it applies in exactly the same way, even if you're not in handcuffs. The arrest context is what made Riley so significant legally, but the non-consent principle runs throughout every voluntary request for access to your device. Let's also spend a moment on the specific situation of being a passenger in a car, because this is another context where phone search requests sometimes happen, and the same framework applies. If an officer asks a passenger to show them their phone, that's a request directed at you specifically, about your property specifically, and you can refuse consent in exactly the same way. The fact that you're in someone else's car that's been pulled over doesn't change the Fourth Amendment protection that applies to your personal device. "I don't consent to a search of my phone" works just as well from the passenger seat. Let's talk about third-party phone searches, because this is a scenario that doesn't come up in the simple single-person versions of these situations, but matters in some real circumstances. What if police don't ask you for access to your phone directly, but instead ask someone else who might have access to it? A family member, a roommate, someone you've shared a device or an account with? The consent rules here get genuinely complicated. In general, someone with mutual access to a shared device or account might be able to consent to a search of the shared portions, similar to the roommate scenario we talked about in the context of home searches. But someone who doesn't have actual access to your phone, who doesn't know your passcode and doesn't have permission to use it, can't consent to its search on your behalf, regardless of their relationship to you. The person who has the authority to consent to a search is generally the person who has the legal authority to access the item in question, and for a password-protected personal device, that's a narrower category than people sometimes assume. Let's talk about your right to know what they found. If police searched your phone, with or without a warrant, with or without your consent, you generally have a right to know what was done, what was found, and how it's being used or considered in relation to any charges against you. This comes through the discovery process in criminal cases, where prosecutors are required to disclose evidence they intend to use, including evidence obtained from digital devices. Your attorney can use this process to get specific information about exactly what was accessed, when, under what authority, and what was found, and can use that information to evaluate suppression arguments, to challenge the scope of any warrant, and to build the factual record for any legal challenge. This is another reason early, complete communication with your attorney about the phone situation is so important, because the discovery process is where the record of what was done gets fully exposed to scrutiny, and having an attorney who knows to look for it is the difference between catching a Fourth Amendment violation and missing it entirely. Let's pull together the landscape of everything we've covered, because I want you to have a complete, organized picture of this before we close. Your phone has the strongest legal protection of almost any item you carry, and it comes from a unanimous Supreme Court decision that says, to search the contents of your phone after you've been arrested, police generally need a warrant. Not just permission from the arresting officer, not just department policy, a warrant issued by a judge based on probable cause, specifying what they're looking for. Your job in every encounter where this comes up, whether at the time of arrest, during processing, at the station, or during any other interaction, is to state clearly and calmly that you do not consent to a search of your phone, to decline to unlock it, to decline to provide your passcode, and to ask for an attorney. The warrant requirement is the rule. Consent is the main exception. Every time you decline to consent, you force the process through the channel that was specifically designed to protect you. Every time you consent under pressure, you waive the protection that exists specifically for this moment. The specifics worth having firmly in mind are these. Being arrested allows police to take your phone. It does not authorize them to search through it. Asking you to unlock your phone is a request for consent. You can decline, saying,
All right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.